Hello, everyone, and welcome to today's webinar, Promoting Diversity and Inclusion in the Workplace. As a starting point, I want to acknowledge that I'm speaking to you today from the traditional and unceded territories of the Squamish, Musqueam, and Tsleil-Waututh peoples. My name is David Wong, and I'm a partner in Fasken's Vancouver office. I'm a co-leader of the Fasken's National Labour, Employment, and Human Rights Practice Group, and the leader of our firm's human rights practice. I'm very happy to be joined today by two of my colleagues, Nicole Singh and Sandeep Tatla. Nicole Singh is a partner in our Labour, Employment, and Human Rights Group in our Toronto office. She spent most of her career at Fasken and spent cumulatively nearly 2 years in-house at two clients' offices where she provided day-to-day labour and employment legal advice to human resources professionals and management. Nicole is passionate about diversity and inclusion in the workplace. She regularly advises clients on achieving a more diverse workforce and eliminating systemic barriers. Sandeep Tatla is Fasken's Chief Equity, Diversity and Inclusion Officer. As a member of the firm's management team, she's responsible for designing and implementing the firm's equity, diversity, and inclusion strategy. A catalyst for change, Sandeep is a forward-thinking executive leader with demonstrated experience successfully leading diversity, equity, and inclusion change strategies across different and complex industries. Her focus is on systemic and sustainable change. Before her role at Fasken, Sandeep held senior roles in the field, including at a global financial services firm and a leading healthcare technology company. Before specializing in diversity and inclusion, Sandeep practiced labor and employment and human rights law. Nicole, Sandeep, and I are all members of our firm's EDI committee. Before we begin, I have a few housekeeping notes. At the end of the webinar, please click the survey button underneath the video window. These surveys help us to determine future topics, and your input is greatly appreciated. The materials for today's webinar can be accessed via the materials button, also under the video window. We're also recording today's webinar, and the recording and materials will be emailed out post-event. During the webinar, if you have a question, please click on the Submit a Question button to send us your questions. We'll do our best to answer all of them that we can. We now have a closed captioning feature as well. If you'd like to turn this feature on, please use the CC button in the bottom of the video window. If you require technical support, please click the Tech Support Chat button and one of our techs will help you out. If you're looking for COVID-19 specific information, we have a wealth of information in our COVID-19 Knowledge Center, which can be found at fasken.com. And last but not least, we'll be beginning our 2021 Year in Review Premier Webinar Series in November. Please visit our Fasken Institute section on fasken.com for all of our upcoming events. And with that, I'll now move on to our presentation. Slide, please. So to start, just very briefly go over our agenda. Today, we hope to cover off diversity and inclusion best practices designed to mitigate legal risk, collecting and tracking diversity demographics, legal considerations for diversity recruitment programs such as diverse slates, evolving employer obligations around mitigating unconscious bias in talent decisions, potential risk and liability for organizations that do not appropriately account for diversity and inclusion. Now, this topic is one that's a pretty hot topic at the moment, leading edge, and there's a lot of things that I think, could be talked about, probably a lot of questions that are out there around it. So we hope that, through today, you'll come away with a better understanding of some of those issues and some of the risks that do exist for organizations as you navigate this area. With that, I'm going to turn the floor over to Sandeep to start us off.
Thank you, David. It's a pleasure to be here with all of you this afternoon. Over the last 16 months, we've seen the focus around EDI grow. We know both from research and experience that issues of social justice have become more important to employees, especially millennials and Gen Z. Investors have greater expectations and want to see organizational policies and actions around ESG. And finally, consumers are becoming more critical about where they spend their dollars, aligning themselves with brands that walk the talk on diversity and other social issues. Not surprising, as David's remarked, we've seen an increase in organizations starting to engage in activities to address EDI. I'd say that in the past years that I've been doing this work, we're really seeing a heightened awareness around these issues. In fact, many in my industry were feeling like we're at a bit of an interesting tipping point and are excited to see this accelerated change. Now, there's an abundance of research and articles on best practices available to help organizations address EDI. And I'll just say for us, when I say EDI, we're referring to equity, diversity, and inclusion. I know in different organizations, there's different acronyms. Just to level set that here at Fasken, EDI is the acronym that we use. So in my experience, what I have seen is very often very well-intentioned people and organizations are taking a lot of different actions around equity, diversity, and inclusion, from EDI policies to mentoring programs to implementing targets and goals, sponsorship programs, employee resource groups, and the list can go on. We've read and we have heard that all of these actions in their own way can move the needle. But I'm often asked, where do we begin? Or more frequently, I'm asked, how do we actually accelerate progress? There's no silver bullet. Change takes time, concerted effort, consistency, and like any business issue, a thoughtful, programmatic approach with clearly defined outcomes and action plans and accountabilities. Invariably in this work, there's risk with both taking action and not taking action. We're always looking to manage employee and customer expectations, reputational and legal risk, as well as weighing business risks in embarking on our EDI journey. Along those lines, a lot of times I'm asked questions around risk, specifically in implementing different EDI programs or initiatives. I'm asked a lot about diversity data collection. I'm asked about, can we set targets? And is it okay to create programs for specific groups? And invariably I'm asked, isn't that reverse discrimination? In today's session, my colleagues and I will address these questions and also more to help you manage some of the risk that comes with embarking on this work. Slide, please. Oh, I think we're at the, sorry, just back. We were at the slide that we needed. So before we delve into some of the specific issues today, I did want to share at a high level with you that when you're designing an EDI program or developing a strategy, there are a few best practices in design that will not only help you mitigate legal risk, but also ensure that you're designing equitably and in ways that identifies and aims to address inequities, and most importantly, moves the needle to creating greater diversity, equity, and inclusion. The first place you always want to start with is, what is the problem that you're looking to solve? And what that requires is really understanding what's happening in your organization and what I call a current state analysis. You want to use data points to identify where you may have some potential gaps or areas of opportunity. You don't have to start big, meaning you don't have to do this across the organization. You can start functionally, for example, with recruitment. Let me just share a little bit more about what I mean by this. A good starting place when you're looking to create a sustainable strategy or plan is to understand what the key issues are in your organization. And the best way to do this is with data, both qualitative and quantitative data. On the quantitative side, it's not just looking at diversity representation. So how many men or women or people of color do we have at particular levels of the organization? That's important, but what's more important is to do a deeper talent flow analysis to see who's being hired, who's being promoted, and who's leaving more than others. Then it's also important to understand the experience of your people. You can get this data via surveys, through focus groups, through your EDI committee, or through your employee resource groups or affinity groups. What's really important here is that you can't make assumptions about what the experience of your people are. Consultation is critically important to really unearth and get under what some of your key problem areas might be. Once you have this data, you'll soon realize where you have to focus and what specific actions you may need to take in order to address some of your more pressing issues. For example, you may be spending a lot of time and money on diversity recruitment initiatives, but after a deep dive, you realize that your focus may need to shift on retaining your underrepresented talent. You may have an organization that's like a revolving door where you bring in a good level of underrepresented talent, but that talent quickly leaves. And as you start to dig a bit deeper, you may realize that might be because you've got lower promotion opportunities for underrepresented groups. And so now you've got a clearer path on what some of the remedies that you may need to approach to address this challenge. Similarly, that's sort of at the organization-wide level. On a smaller scale, you may want to take bite-sized pieces. So, for example, if some of you on this webinar are responsible for recruitment, you may be tasked, with increasing diversity recruitment. And there's a number of things that you can do, from unconscious bias training to blind recruitment, to expanding your candidate pools, to bringing in technology that removes bias from your job descriptions. And I could probably talk at length, and actually we could probably have just a seminar on diverse recruitment strategies. But there's a lot there. So where do you start? And again, if you start with the what is the problem I'm looking to solve approach, you want to start with the data, and you want to start at the first step of your recruitment process and ask yourself, are underrepresented candidates applying to your organization? If no, then that's where you start. But if you look at your data and you see, we've got a pretty good representation of talent coming in and applying for our roles, then you go to the next stage of your process and you look at, well, are those candidates making it through our first screening process? And if the answer there is yes, that's fantastic. You can move on to the next stage. However, if you look at your data and you see actually, well, they're not actually making it through as much as other talent is, that is where you want to start to then dig a bit deeper and understand, is there bias with the screeners? Is there any bias in your processes or your criteria that are preventing different groups from getting through? So you can see as you go through the process, you'll be able to identify the particular problem and then design solutions to address that. Next slide, please. So another important step around designing to ensure that you're mitigating risk and actually addressing issues of EDI is the importance of consistency and follow through. So once you've identified what the problems are and you've identified some actions to take, are you doing what you set out to do? So from my previous example, if you've identified some gaps in your recruitment process, have you just sat on that information, or are the interventions or actions you're actually choosing to do not actually addressing the root cause? I've also found that a lot of times really great diversity plans or strategies are developed and they sit on the internet, or they sit with EDI, but no one actually really knows who is responsible for the work and what you're setting out to do. So that takes me to the second point. Who's responsible for what, and are they aware of their responsibilities? Have clear accountability and responsibilities been assigned? Do the people who have accountability to drive some of the EDI actions and who have influence over the different systems and processes know that they have to take action, and under what timelines? Next, are you holding yourself or those accountable to deliver on their commitments? What is the consequence to those who don't take action? We all have a lot on our plates, and when EDI comes in and adds an additional item without real consequence of inaction, EDI actions tend to be deprioritized when real work comes in. They tend to be seen as nice to do's versus must do's. And when I say real work, I think what people prioritize is work that people's performance is evaluated on, or for that which they are paid or paid out bonuses. So think about that as you think about the design and execution of any EDI programs and initiatives that you have. The final point on this slide that I wanted to talk about is, has the consultation with employees continued? So I talked about the importance of consultation early on to help identify what some of your challenges or issues are. But equally important, when you're designing and implementing programs, you want to ensure that there's consultation with different groups. I'll use the example of a leadership program for people of color. Have you consulted with the group to understand what the key challenges they face are or their specific needs? Or are you making assumptions about their need for additional training without any specific input from them? Bias can come into play, and a program designed without consultation can actually perpetuate stereotypes and biases. So engagement early on in design not only addresses some of the problems that you're trying to address from an inclusion perspective, but it also minimizes both legal and reputational risk. Finally, for any strong program into design inclusively, we can move on to the next slide. What we want to focus on is, are you recalibrating at some regular cadence to make sure that the programs and the initiatives that you have adopted are actually resulting in the change that you're looking for? And so taking a step back, when you actually identify the problem and then think about the solutions that you're going to take to address the problem, you should set out clear, measurable results. What will good look like? What are the key performance indicators to indicate that you've been successful in adopting your particular initiative or action? And then track against that to make sure that you're actually moving forward with your actual programs or initiatives. On the policy side, what I would say is, are your policies actually creating the culture that you're looking to create? And if not, what's the gap? And it may not actually be the policy itself. You may have a really strong policy, and I've seen this before, but no one knows about the policy. And so have you trained on the policy? Does the policy go far enough? I've also put here psychological safety, and this is a big one that I see. There's always really great policies out there, but people may not feel safe actually making complaints or raising issues. And so you really want to get under if it is actually an environment where people can actually act on any policy that you have. Similarly, on the programs, are the programs achieving what you set out to do? And in your recalibration, a lot of times what comes up is that there may be that you've kind of addressed one particular issue, and then you kind of dig a bit deeper and you realize that there are some other issues that you may need to address. So recalibration is really important to ensure that you're always acting to address those key challenges that you've identified. And finally, getting back to the employees around consultation, but do you have some sort of feedback loop so that you can track your progress and understand what the experience of the employees is? And so that could be in a formal way, but it also, a number of organizations have employee resource groups, and those are really great ways to make sure that you're keeping tuned in with how your strategy and plans are landing with different groups. So finally, in this section, I'll say before I pass it on is to avoid both the reputational and legal risks. You really need to ensure that you do what you say and you continue to demonstrate best efforts to achieve any of the goals or commitments that you set out. I did start this by saying that the data is really important to help you identify and unearth what some of your potential problems are. And so I'm going to pass it on to David now to talk a little bit about the law around data collection, and I'll be happy to provide some practical examples of how you can also mitigate risk in that area. David?
Thanks, Sandeep. And just before I touch on the sort of legal side of the data collection, I just want to reiterate from the legal risk perspective, and you'll see it as, I think, a bit of a running theme here, that planning and really taking into consideration what are, the opportunities, how you're going to address them and actually implementing them. That is so important from the perspective of also mitigating the legal risks and addressing the issues. Because I think a lot of the time when it comes to EEI, the intentions are good, but if you're not taking the time to actually plan properly and really think it through and think of the consequences of what a program or policy may be, you actually may be creating more legal risk. And Sandeep touched on that to some extent in some of the policy comments. So with that, on to the diversity data. And as Sandeep said, this is a question that often does come up. Can we in fact collect diversity data? There's privacy issues, there's human rights issues that come up with this type of question. As you can see in the slide there, it isn't illegal per se to collect EDI data. So there's no law that says you cannot collect EDI data. But obviously, as I mentioned, in some jurisdictions, there's privacy legislation that needs to be taken into account when you are considering collecting personal sensitive information like this. And there's also human rights considerations that do come up as it relates to the collection of this type of data that you should be thinking about. As Sandeep said, really though, the collection of data is critical for informing of the opportunities first that exist and what you actually are going to try and do with your EDI. If you don't have the data to start with, then you're sort of shooting into the dark in terms of putting these together. And so I think it's an important step. Again, in terms of those risks, it's jurisdiction specific. So obviously when you're doing this, you'll need to look at, where am I? What is the legislation? Is there legislation from a privacy perspective that I need to comply with? And where there is, it's sort of consistent in terms of what's required. Informed consent, not necessarily being mandatory, and ensuring there's good protection, and disclosure, limiting disclosure, and you're only using the information for the purposes that it needs to be, and again, that you actually have a good purpose for collecting. So all of those things should be considered when you're looking at the collection of diversity data. From a human rights perspective, there's risks in asking and knowing about diversity information. The fact is, if you don't happen to know something, it's possible, when it makes it a lot harder for a human rights complainant to suggest that a decision was made on the basis of a diversity factor, I'll call it. In terms of a defense to a human rights complaint, it actually might be a little bit easier for you. But that's not to say, it's not a good reason not to get yourself informed, again, from an EDI perspective. What I would say in that regard is just be careful not to over ask. If you don't need to know the information, then don't ask for it. Slide, please.
Sorry, David, before you move on, I just add a couple of practical pieces if you are collecting data that have worked to help mitigate risk. One, really consider who has access to that data. So even within your HR organization, generally in the places I've worked, it's been very limited to a very few people who would have access to the individualized data to actually create the reports. It's like one or two people have access to that data. And then finally, in most places, I didn't have direct access to that. I would only see aggregated reports. And then even when you create reports, you have to be really secure around who has access to them and who you share them with, for the reasons that David shared, is that you don't want that data getting into the wrong hands, because the purpose of creating these reports is to identify what problems you have. And so you want to be careful around how those reports get disseminated and who has access to them. The other thing that I think that David touched on, which is critically important, is, a lot of times we want to be really over-inclusive. And when we're collecting data, we want to ask a whole bunch of data under each demographic group. And the question I always ask is, well, what are you going to do with that data? Like, are you just collecting it for collecting sake, or are you actually going to use that data to actually understand and make change to your practices and policies? And if you're at the stage where well, no, we're not specifically going to address, specific challenges based on people's, what country they come from, for example, then you shouldn't be collecting that information, because it's not informing the work that you're doing. So always keeping that in mind is critically important.
Great. Thanks, Sandeep. On now to policies, and again, Sandeep spoke to this. Having EDI policies, obviously it's a good thing in a lot of different ways. For the running theme of making sure you know what you're doing and you're planning, having a policy in place can be great. It can help you sort of focus, define your approach, and ensure that you've got a consistent application when you're moving forward. But for those of you who have joined us for some of our prior webinars and in-person seminars on human rights, you may have heard me speak about the Lewis and WestJet airline saga, and caution against drafting overly broad policies. So again, and I think this comes up in particular when we're talking about EDI, because again, I think the intentions are often really good in terms of what people are trying to do and what they want to be accomplishing. But if you put in a policy, that you're going to be doing something as an organization and you don't live up to it, you're creating legal risk that didn't exist before. You're effectively creating a legal action that can be brought against you. So, while it's good to have those good intentions, it's important in these policies that you're realistic about what you're doing and that you don't overpromise where you go. And it also, in terms of those policies, it'll give you that opportunity to consider, if you're instituting a program, who's going to be excluded from it and how is that going to work with respect to sort of prior disadvantage for those kind of groups, and consider discrimination in that regard as well. So there's a lot to think about when you're into that policy step. I'll just briefly touch. For those of you again who have joined us before, you may have heard me speak on that Lewis and WestJet Airlines case, but I'll just give an update because the last time I spoke on it, we were talking about a BC Court of Appeal decision. Since then, the BC Supreme Court has weighed in. The Court of Appeal sent it back as they had not, barred it from moving forward on the basis that it raised human rights issues. So the BC Supreme Court looked at it again and decided that, for those of you who don't know what was at issue, was allegations that WestJet hadn't lived up to the promises in its anti-harassment policy relating to alleged sexual harassment of a flight attendant. And what the BC Supreme Court said, it was a class act. It was brought as a class action, and the court said it doesn't belong as a class action in court. This is, can be addressed through the Canadian Human Rights Act. There's both systemic and individual remedies available there for the individual. So we're not going to certify this as a class action. But they said there's also the possibility, current employees could file grievances. So there was the union now is in and representing them. So there could be grievances, and former employees could also bring civil action. So it's some good news, a little bit of an update on that side of things for organizations, in that, class actions may not be coming at you, but it still means that individual employees can file actions through court if you don't live up to your policies. So if you're putting promises that are overly broad into policies, whether they be EDI or anything else, you're creating that risk, and that can be through a human rights complaint, it can be through court. So again, just a word of caution when you're looking at these policies, don't overstep. Slide, please. With that, I'm going to now turn the floor over to Nicole to talk about EDI concepts.
Thanks, David, and good afternoon, everyone. So as David mentioned, I'm going to be talking about some EDI concepts. And of course, any presentation on EDI, it would be helpful for all of you for us to review some key terms. So to that end, a few key terms that we want to discuss and review with you are the following. So bias, and we'll be talking about explicit and implicit bias, racial profiling, and microaggressions. Next slide, please. So in terms of biases, they can be explicit or implicit. We're all aware of explicit bias. That's obviously clearly wrong. That's when you have a very conscious and deliberate thought. So that could be something like men work harder than men and men work harder than women. And so you have a conscious held belief about that, and you have a deliberate thought about that, and you act on that bias. That's explicit. That's something that we all know is wrong. We all know should not have any room for that in the workplace. But what's more concerning, because it's not known, is implicit bias. So implicit bias, it can result from past experiences, expectations, or stereotypes that form an opinion in your mind that you may not even be aware of. So it's involuntary and unconscious. Again, it's based on your experiences in life, stereotypes that you may have formed that are based on experiences or things that you've witnessed in life, but they may not actually be known to you. And so in some ways, the implicit biases can be pretty dangerous, and even more dangerous because you're not even aware that you hold them and that you act on them. Next slide, please. So we want to unpack unconscious bias a little bit more, because it's something that while we know that conscious bias is wrong, we often don't even realize that we hold unconscious biases. So again, it's an implicit attitude or motivation. And again, it's not deliberate, and it's often unintentional. So people often don't realize they're making unfair assumptions or stereotypes. And these unconscious biases can relate to a number of things. It can relate to gender, it can relate to age, ethnic, or cultural bias, though that's not an exhaustive list. In terms of biases, there are a number of different biases that one could hold. And of those biases, a number of them are not on their face discriminatory in terms of legal risk. However, a number of them can certainly result in legal risk. So the first one being affinity bias. That's when you unconsciously tend to get along with others who are like you. So perhaps you enjoy, for example, a particular sport, and so you get along with those who enjoy that sport as well. Or you have an interest in travel, and so you naturally gravitate towards people who like to travel as well. That's affinity bias. Beauty bias is favorable treatment that individuals receive when they are deemed to be more attractive. Perception bias is when our perception is skewed by the stereotypes and assumptions we have about other groups. Confirmation bias is favoring information that confirms your previously existing beliefs or biases. And halo horn effect, those are both basically opposite ends of the same thing. So halo effect is when positive impressions of a person in one area tend to positively influence your impression of that person in other unrelated areas. The opposite of that is a horn effect. So that's when you have a negative view of someone or of a trait that they possess, and automatically that causes you to have negative views about that person in other unrelated areas. And then finally, performance bias. That's based on deep-rooted and incorrect assumptions about others' abilities. So we'll get into shortly how those biases can pose an issue in the workplace. But before that, just want to briefly touch on how to avoid unconscious bias. Next slide, please. Oh, actually, you're on the right one. Sorry, if you can go back. Thank you. So the first is to be honest with yourself. We would all love to believe that we operate in the workplace and in life without any biases, but the reality is all of us have unconscious biases. So the first step is really recognizing that you may very well have an unconscious bias that you hold, and taking a clear look at what those biases might be and how you might be perpetuating certain stereotypes within the workplace. You should also avoid snap judgments and base decisions on facts and observation. Next slide, please. So the next concept we want to discuss is racial profiling. And that's a concept or a practice that most of us are probably familiar with now. It involves differential treatment or scrutiny because of negative stereotypes related to a person's race, though it can also relate to things such as religious beliefs, color, ancestry, or place of origin. Individuals in the workplace who are subject to racial profiling may feel degraded, humiliated, and may suffer emotional, financial, and social tolls. It disempowers individuals, and they may lose trust and confidence in the ability of the organization to serve and treat them fairly. So it goes without saying that you obviously want to ensure that racial profiling is not a practice that exists in your workplace, and that you want to ensure that you have training and policies in place to ensure that racial profiling is not occurring in your workplace. And shortly, I'll discuss a case where racial profiling was something that took place in a workplace and had negative consequences for the employer. So the final practice or term that we wanted to discuss is microaggressions, and that's a term that has been consistently been used increasingly when talking about EDI concepts. So what is a microaggression? It's a behavior or communication, spoken or unspoken, that feeds into certain types of stereotypes about individuals. It can be intentional or unintentional, and it can demonstrate unconscious bias or stereotyping. Often microaggressions are experienced as racism, sexism, ageism, or ableisms. And they often involve slight indignities, put downs, and they're often experienced in day-to-day interactions. For those who are the subject of microaggressions, it can make them feel uncomfortable, unsafe, and like they're working in a toxic environment. Next slide, please. So the key thing about microaggressions is that, again, people are often unaware that they have engaged in the offensive or demeaning behavior or language. Microaggressions are often communicated through language, so it's very important to pay attention to how we talk and what we say in the workplace. And the recipients of microaggressions often feel insulted, but they don't often know how to respond to the microaggression. Next slide, please. So we've put up here some examples of workplace microaggressions that either we've come across from clients who are telling us about incidents in their workplace, or just commonly known forms of microaggressions. So I'm not going to go through each one, but just to give you a few examples, the very first one, you're so articulate. So what's an example of where this could come up? It could come up, for example, if you're in a boardroom and a visible minority is speaking and you then comment, "You're so articulate." The microaggression there is an underlying assumption that this person may not be naturally articulate. This person is surprising to you that they are articulate. So making that comment, the person who's making it may not realize that they may actually think it's a compliment. They may actually think it's a good thing. But the underlying tone of that, "you're so articulate," is an underlying assumption that this person may not, you're surprised, this person may not naturally be articulate. Another example is calling a woman hysterical, shrill. These are based on assumptions, incorrect assumptions of women being overly emotional or more emotional than men. So that's another example. And another one is, are you in the right room? So where could this arise? This could come up, for example, where, again, we'll use the boardroom example, where someone walks in and perhaps they're a woman, for example, and you made the assumption that, they may not be in the position that they're there for. They may not be the client, for example. You may assume that they're the receptionist. These are all forms of microaggressions that are based on what you perceive or what an individual might perceive a woman in that example to be, the type of positions that they hold. So these are just some examples of microaggressions, obviously not an exhaustive list, but certainly things that should be avoided. So the big question is, where may these issues arise? So issues of microaggression, issue of racial profiling, and the like. So as Sandeep actually already hit on, these issues can arise at the very beginning of an employment introduction. So recruitment and hiring. Often, this is where you can actually get off to the wrong foot as an employer, is where you have things like biases and racial profiling. If they're not addressed appropriately, if you don't have training on these things, this might be someone's first introduction to you as a company. It can also arise in promotions and in customer and employee relations, and I'll unpack each of those. So in the very first one, recruitment and hiring, next slide, please. This can come up easily in the application stage, and particularly where employers are hiring for fit or culture. Now, of course, that's dependent on what your fit or culture is, but if your culture is one that's a long-standing culture of a singular race, a singular gender, or socioeconomic status, hiring for fit or culture may actually be perpetuating an environment that is not one that is in line with EDI, is not in line with what the company says their goals are. So The halo effect or the horn effect, or also I'll discuss the affinity effect. As I mentioned earlier, these biases can, on their face, may not seem problematic, but if you engage in them or act on them, they can have very problematic implications. So for example, the affinity bias. Just a reminder, affinity bias is where you gravitate or typically like to associate with people who share common interests to yourself that basically you can identify with. The problem with that bias at the recruitment stage is, so for a perfect example, the interest section of a resume. If you are a recruiter working in human resources and you see, for example, that the applicant enjoys golf, nothing is wrong with golf, but just using it as an example, if you then latch onto that and then your entire conversation is all about golf and you then are looking for applicants who have similar interests to yourself and you had this great conversation with this particular applicant because they share a similar interest to you, inadvertently you might be trying to recruit people who are exactly like you, which a lot of us think there's nothing wrong with that because we all think we're great. And that's not to say we aren't all great, but part of the problem is you might then end up with an organization that is not very diverse. So with the affinity bias, you may end up inadvertently recruiting individuals who are one race, one socioeconomic status, one gender. So that's the problem with these biases and how it can impact the recruitment stage. The other area where it can have an impact is in performance and reviews. So again, if you're reviewing individuals' performance based on biases, and if you're viewing them through these biases, unfortunately, you may find, and as Sandeep said earlier, that when you look at the promotion in your workplace, you see that you have a lot of diversity at the early stages, but later on, you're seeing fewer and fewer diverse individuals. And a lot of times, the reason for that is because of certain forms of biases, and again, unconscious biases. So ones that we're not even aware of, hence the need for making sure that we're alive to how these biases work. Next slide, please. So in terms of employee and customer relations, organizations should, of course, be mindful of EDI concepts when engaging with employees, but also with customers and clients. Workplaces should remain safe. Of course, this goes without saying for everyone. So it should be an inclusive and professional environment for everyone, being employees, customers, and clients alike. And I'm going to go through some examples shortly about the consequences, again, if you do not make sure that that your workplace is one that's free of discrimination, free of these types of biases. But before that, I will turn it back over to David, who will talk about human rights complaints.
Thanks, Nicole. Slide, please. So as Nicole said, we're sort of shifting gears now to a little bit more of the legal side and some of the risks and challenges and things to think about when you're considering the potential legal liability that can arise, both if you don't implement EDI programs properly, or if in fact you don't, take EDI seriously and address EDI considerations in your workplace. So before we get into some of the cases, Nicole's going to be taking you through of examples of actual complaints. I'm going to talk a little bit about first, the structure, I guess, of the human rights system, I'll say, as it relates to these possible complaints and some of the things to think about. So the slide we have here is a slide, again, I've shared before in some of my prior presentations relating to special programs. So what you'll see is various jurisdictions, in fact, all of them across Canada, do have provisions protecting what we all refer to as special programs from being discriminatory. So sometimes those, can be referred to, say, as affirmative action programs, EDI initiatives, these sorts of things that are really designed to improve diversity and address some of the issues that exist do have protection to some extent under human rights legislation. Now, again, these programs, it's important to note that by their very nature, a lot of them are prima facie discriminatory. They exclude those who don't fit within the groups that you're trying to, the disadvantaged groups where you're trying to address those issues. Now, that on its own will create risk of human rights complaints because of that distinction, because of that existing prima facie discrimination. And again, you'll have to often rely on these sorts of exemptions in this legislation to fit if you were to receive a complaint. Going back to sort of the running theme here that I've mentioned and Sandeep has talked about, it really is important when you're looking at this kind of issue and you're considering the risks, again, to carefully consider the reason and purpose of the program or initiative, and how you've defined, who is going to be targeted, who it is this program aimed at. You'll see when you go through the various legislation that, it's really important that you do take that step and make sure you're fitting within it. For example, in Alberta, and now, this legislation is not consistent across the board in terms of what it requires. So where you are in, one jurisdiction or another, if you're in multi-jurisdictions, you really need to pay close attention to the legislation and see what it actually says as it relates to what's protected as a special program. You'll see in the column on the far right, there's pre-approval available for some of the programs, and I'll talk a little bit about that. But before I do, again, some of the differences between the jurisdictions. So in Alberta and BC, there's a requirement that the special program achieves or is reasonably likely to achieve its objective. So that's part of the legislation. To fit within a special program, you have to meet that test. So that is something, to think about. It's not an automatic. So if you were to implement a program, you're not automatically going to be achieving or reasonably likely to achieve the objective. And ultimately the tribunal will make that call and decide, are you reasonably likely to achieve that objective through this program? If not, you're not actually protected, and a human rights complaint can proceed against you for that program. In Ontario, another example, the special programs provision provides a right under Part 1 is not infringed by the implementation of a special program designed to relieve hardship or economic disadvantage, or to assist disadvantaged persons or groups to achieve or attempt to achieve equal opportunity, or that is likely to contribute to the elimination of the infringement of rights under Part 1. So it's framed differently, and it's not necessarily going to be, the same test that will be applied if you're in Ontario versus, say, if you're in Alberta and BC. In Quebec, the legislation provides that certain affirmative action programs are not discriminatory if they're established in accordance with certain legislation that's referenced in the legislation, depending on the nature of the program. So again, in Quebec, you'll have to look at different considerations. It may be ultimately a lot of the programs will fit within the special programs legislation for each of these jurisdictions, but it's certainly not a guarantee. And if you're multi-jurisdictional organization, I think it's going to be very important that you do pay close attention to the actual legislation and the wording to make sure that your program fits within it. Otherwise, you're at risk of human rights complaints. And that takes me to that last column there on pre-approval. So you'll see in some jurisdictions, there is the ability to apply for pre-approval of a program. I would suggest that where that is available, and where there's any gray area, if you have any concerns that you might face a complaint, with respect to the program that you're implementing, it's a good idea to get that pre-approval. It will obviously address, if you do get it in advance and a human rights complaint comes along, it's going to save you a lot of time, a lot of resources, and a lot of money if you've already got that pre-approval, because it's a pretty easy application to say pre-approved, can't be discrimination. That's the end of it. If you haven't got that pre-approval, now you're into having to prove that you fit within that test in that legislation, like I mentioned. That's going to be a more complicated process and risky, because you don't necessarily know what the adjudicator is going to say at the end of the day. And if you don't fit within it, well, then you could be on the hook for that human rights complaint. So you'll see, again, the certain jurisdictions you can do that, certain ones you can't, and you'll just have to roll the dice. Next slide, please. So next, again, this is sort of in the context of just the processing of human rights complaints rather than the substance. There's a shift in, with this focus on EDI and more awareness in society generally out there relating to these types of issues. There's a shift in adjudicators, mainly at the tribunal, but I would suggest it'll go further than that, including courts and other places, in terms of how they approach these types of issues. The BC Human Rights Tribunal has issued a report, the Expanding Our Vision, Cultural Equality and Indigenous Peoples Human Rights report. And obviously, you'll all be aware of the Truth and Reconciliation Commission and its recommendations. And so this sort of flows from that. And what it is our tribunal out here in BC's recognition that there's access to justice issues that relate to Indigenous peoples that come from much of the history and the context of the systemic barriers that have been put in place for them. And the tribunal's recognition that it needs to shift its processes and be more responsive to the experiences of Indigenous peoples when it comes to the processing human rights complaints. What that means from a practical perspective is that when complaints come in the past, some of these complaints would likely have been dismissed at an early stage, or maybe moved off to a certain stream in a certain way without really considering these types of issues. And now I think the tribunal is going to be a lot more sensitive to them, and it may mean that complaints that otherwise would have been dismissed are going to get moved forward, and organizations are going to actually have to address the substance of them. Next slide, please. So now speaking more about the substance. So this sort of same shift when it comes to assessing human rights issues, but looking at what are adjudicators doing with respect to assessing it, and how is the shift affecting them? So again, this is a decision, the Campbell decision. I'm not going to get into the facts. I spoke about it before at last year's Year in Review webinar series, but I think, again, it's important to just sort of have a reminder in terms of the approach that these adjudicators are taking. Here, what was at issue was the treatment of an Indigenous mother who witnessed the arrest of her son, and whose treatment by the police was insensitive to and didn't account for historical disadvantage of Indigenous people, including their historical treatment by the police. And so while the police in this case didn't actually say or do anything directly discriminatory, no racial comments, nothing like that, it was their lack of consideration for that social context which resulted in the tribunal finding there was discrimination. And taking into account colonialism and historical trauma and the effects on the mother that this treatment by the police had, that was really what the focus of the decision was. So it's important for this discussion to be aware of. It's not simply a matter of not saying something racist or not directly tying something to somebody's gender or whatever it may be. It's in fact being aware and making sure that your organization and those individuals in your organization are aware of context and all of the things that they need to be aware of, so they aren't doing things that are systemically discriminatory, which your organization could be liable for at the end of the day. Next slide, please. So, along the same lines as the decision of Fraser from the Supreme Court of Canada. Now, it's a very different decision, and it arose under Section 15 of the Charter. And realistically, I do not have time to properly comment on it in the way that it deserves. But where I think it's important for this discussion is, again, in terms of how the courts are looking at the issue of systemic discrimination and what's required. So what was at issue here was a pension plan, and it was an issue around job sharing. So those who went for took job sharing options, they were then treated as part-time for the purpose of the pension, and that's what they received. They didn't have the option to buy back full-time pension, but they did have the option. They were still covered by this pension, and so the designers of the pension plan thought they were actually, accommodating people who were in these job sharing arrangements in a way that was fair and reasonable when they had introduced this job sharing. Well, the court went through the analysis and effectively found that because those who went off were suspended or on other kinds of leave, they had the opportunity to buy back pension, just like full-time employees, whereas those on job sharing didn't, coupled with the evidence of the data. So this is really where the discrimination came in. it was evidence about the situation of the group. So those who actually were part of that job sharing group were by far, it was mainly women, and mainly women with families. And so that data combined with that framework was enough for the Supreme Court of Canada to say that there was a breach of Section 15, the right to equality. So I'd say similarly, systemic discrimination analyses by, say, tribunals will take that kind of approach. So again, nothing overt there in terms of meaning to discriminate against women in the design of this plan, but its effect was. And so again, it's important when you're looking at your organization and what you've got in there, you're addressing systemic discrimination and ensuring the effects of what you've got are not discriminatory. Next slide, please. So with that, I'm going to turn it back over to Nicole now to talk more about the risk and liability associated with this area.
Thanks, David. So as David said, the failure to account for EDI and discrimination within the workplace can have pretty significant consequences. And as David also said, there's a shift among adjudicators at this stage, largely at the human rights tribunals, to take into account systemic discrimination, institutional racism, and these types of concepts. However, we are seeing a shift more and more to other adjudicators, courts, for example, taking notice of these types of things. So a number of decisions, and we'll be reviewing them with you shortly, show that adjudicators are starting to have a zero tolerance towards things like racial profiling, discrimination, and harassment. And what we're seeing is increased damages, which David will touch on shortly, but increased damages for a number of things. So in the human rights context, we're seeing increasingly larger and larger damages on account of human rights damages for things such as injury to dignity and mental well-being. We're also seeing special damages, so that's another head of damages that could be awarded for not taking EDI into account in the workplace. It can also result in aggravated and punitive damages. So, as many of you know, that would mean where an adjudicator is essentially punishing the employer for either engaging in a certain practice or, not taking into account EDI considerations. And another risk that we put up there is constructive dismissal. So oftentimes when people hear about constructive dismissal, they think more about changes to the terms of employment, like reporting level or your salary or promoting or demoting you, rather. Constructive dismissal can also arise, though, where someone is subjected to a toxic work environment on account of being discriminated against or harassed. So these concepts of racial profiling, people who are subjected to various types of biases within the workplace and are not promoted for these reasons, for example, they can have very real consequences. The last one being that constructive dismissal. So they can actually take the environment they've been subjected to, a toxic work environment, they can say that actually amounted to them being dismissed from the company, and the company would then be liable for damages on that basis. And the last risk that we put up there is reputational harm, and that one can't be understated. So obviously, the legal liability can be significant, but in many respects, reputational harm can be just as, if not more, concerning. So we'll touch on that shortly as well. So in terms of remedies and what is the liability that an employer can face if they don't properly account for EDI, well, the reality is, and Dave will touch on this shortly, but the reality is that the remedies are getting larger and larger in terms of financial remedies. So we're seeing damages ranging from, as low as 20,000, which may not seem all that low, but as low as 20,000 to over 150,000. And when adjudicators are looking at how to assess the appropriate remedy, they look at a number of things. So that would include the nature of the behavior. So how egregious was the behavior? The frequency of the behavior. Is it a one-off or did it happen multiple times? The circumstances of the victim of the behavior. So did they suffer significantly? How impacted was the victim? So they'll assess things like the vulnerability of the victim and the psychological impact that the behavior had on the victim. Next slide, please. So the very first case that I want to talk about today is Graham and Enterprise Rent-A-Car. And this is a case where we saw racial profiling come up, and it really very much highlights the need to ensure that your employees are well trained on these concepts like racial profiling, and that your organization has a zero tolerance towards it. Otherwise, you can face pretty significant liability and implications. So what were the facts in this case? Well, first off, it's a case from just last year, May 2020, and it's a human rights case, so the Human Rights Tribunal of Ontario. And here the applicant alleged that Enterprise discriminated against her on the basis of her race, color, and place of origin in her dealings with Enterprise as a customer. So who was the applicant? Well, she is a Black woman, and she had pre-booked a car rental online with Enterprise. An online Enterprise policy stated that renters would be required in renting a car to produce a credit card and a driver's license when picking up the vehicle. These were the only two requirements that were listed on their policy online. So when she went to rent the car, she showed up and she produced those two pieces of documentation, the credit card and the driver's license. However, after providing that documentation, the employee then asked her for a second piece of photo ID. And at that time, the applicant advised him that she only had a health card and handed it to him. The agent glanced down at the card and returned it to her, saying that it wasn't a valid form of photo ID. So at this point, another agent commented that they had a lot of car thefts, and that was the reason why they required a second piece of ID. And I'll remind you, that was not part of their policy online, that they would require two pieces of photo ID. So the agent who was originally dealing with the customer eventually just throws his hands up, says that he has no need to explain anything to the customer, and then he walks away. He speaks with his manager, and at this point, the applicant overhears their conversation where the manager basically says, "Don't rent her a car." So the applicant began to feel naturally upset by this situation, and she felt she was being racially profiled. At that time, there were two other gentlemen within the location. It was two white men with briefcases who were also in the process of trying to rent a car. Notably, they were not asked for any identification, or rather, they were not asked for additional identification. So only the one piece of identification that was listed in Enterprise's policy. So while speaking with the manager, the applicant called their customer services line to make a complaint. And after the call, the manager approached the applicant and asked her the applicant approached the manager and asked whether they would be renting her the car, and he said no. When the applicant asked them why was she not going to get the car, they responded first that it was because she hesitated to provide the second piece of identification, but then later said the real reason he wasn't renting her the car was because she was being disrespectful. So shortly after that, the applicant left that location, which was at the airport, and went to a different location, which actually happened to be owned by the same company. She didn't realize, and she went to try to rent a car. She was granted her request. She got the car without a reservation and with the same driver's license and same credit card, and was not asked for additional identification. Next slide, please. So the finding, in short, was that the applicant was subjected to discrimination and unconscious bias. So the tribunal found that the applicant's race and color were indeed factors in the agent's requirement that she provide that additional piece of photo identification. The tribunal also found that the applicant's right to equal treatment under Section 1 of the Code was breached. So the tribunal found that the manager made that decision not to rent the applicant the car based on the agent's recommendation and without first having spoken to the applicant. The tribunal also found that a second piece of identification was not part of the company's policy, and so essentially the manager asked for it ad hoc and without a justifiable reason. The tribunal also commented on, as you'll recall, the manager said that ultimately said the reason he didn't rent her the car was because she became angry. So the tribunal commented on that and said that the focus on her reaction, it reinforced a stereotype of, and I quote, the angry Black person. The tribunal found in the circumstances it was absolutely reasonable for the customer to become angry. Once again, the company asked her for a piece of identification that was not set out in the policy. So one of the reasons we bring this case to your attention is because of the tribunal's commentary on discrimination, which again, as we said, adjudicators are taking note of these EDI concepts and are becoming the decisions and the remedies they award are very much drastically tied to their deep appreciation for these EDI concepts. So in coming to its conclusion, the tribunal acknowledged the well-recognized principles regarding subtle forms of anti-Black racism. And the tribunal specifically recognized that a Black person can be treated adversely by a service provider because of conscious or unconscious stereotypes of Black people being criminals. And I'm actually citing from the decision there. So the other thing to take note of is that the tribunal recognized that discrimination is often subtle and can be very difficult to prove. Another key point is that the discrimination didn't need to be the major factor or the sole factor of why, in this case, the applicant was not given the car. The fact that it was a factor, the fact that the manager attributed the increase in thefts in the area and his desire to have her produce an additional piece of identification, whether or not he provided additional reasons of why he didn't rent the car, such as she became angry or because of his concerns of thefts in the area, the fact that the discrimination was a consideration, a factor in his decision to not grant her the car was sufficient to prove discrimination in this case. So next slide, please. So the remedy here was $2,500 for injury to dignity, feelings, and self-worth. This is notably on the lower end of the scale, but as David will present on in a moment, that is very low, and what we're seeing are increasingly higher awards than that. But notably, in this case, what one of the remedies is that the company had to provide human rights related training to all management and customer service staff. So this is an important point because as we've been talking to you about in today's presentation, it's so important to have this training, and where you have this training in place, you may actually avoid situations like this from happening, and of course avoid. Here it's only $2,500. However, in other cases it's much higher, and in other cases the reputational harm could be much more significant than a $2,500 remedy. Next slide, please. So the other case that we wanted to talk about is Coca-Cola Canada Bottling Inc. This case is an important one because, as you'll recall, Sandeep and David talked about earlier, that you have to be careful of not over-promising or becoming too rigid in trying to ensure that you're accounting for EDI. So it's obviously important to make sure that you're accounting for it. It's obviously important to have a zero tolerance policy. However, the usual factors that come into play for disciplining employees, such as progressive discipline, taking a holistic view of the circumstances, those do not go out the window simply because you are trying to take EDI concepts very seriously. So the decision here in this case is actually somewhat of a controversial one. It is a BC Labor Relations decision. And here, a unionized bottling plant employee was dismissed for wearing a COVID mask that had a Confederate flag and the words, "The South will rise again" on the mask. He wore it while at work, and the incidents notably occurred several weeks after the murder of George Floyd. So this was last year. And disturbingly, it was a week after an incident within the workplace where a noose was found within the workplace. And so at the time that he showed up with this mask, the supervisor actually wasn't aware of the meaning of a Confederate flag and Googled it and learned that it can be a form of a racist symbol. So as a result, the supervisor asked the employee to remove the mask, which he did. He did it immediately and without objection. Following this incident, the employee was terminated after a very short investigation. And the reason for his termination was not only because he wore the mask, but also because of the noose incident I mentioned. So as you recall, a week before the incident, the employer found a noose within the workplace. They were unable to identify who put the noose in the workplace. And so they asked for people to come forward. They interviewed a number of employees, and one of the people they interviewed was this same employee. And when he was interviewed, his response to the noose incident was that he didn't think that the person who put the noose there had any ill intent, that they probably meant it as a joke, and that he didn't see it as any form of harassment or racist. So in the termination letter, the employer actually relied on not only the fact that he wore the mask with the Confederate flag, but also his reaction to the earlier instance of what the employer deemed to be workplace racism. So the employer argued that the fact that he wore that mask and the fact that he responded just a week earlier to what it viewed as a racist incident as a joke required immediate termination. They had a zero tolerance policy and a zero tolerance reaction to this incident. The union agreed that wearing a Confederate flag on your mask is a problem and that it was improper. However, they did not feel that it warranted an automatic dismissal. They thought that a lower form of discipline would be appropriate here. Next slide, please. So perhaps surprisingly, given the current climate we're in, the arbitrator actually reduced the termination to a 5-day suspension. But it's important to take a look at the reasons why the arbitrator did so. So the first was that the employee removed the mask right away. So he didn't object to it. He didn't make any justifications for wearing it. He simply removed it immediately upon being asked to do so. He apologized, though I should note he apologized at the hearing, not at the time of the incident. And the adjudicator, surprisingly, I would say, said that there was no intention of using the mask to promote racism. As you'll see in a lot of human rights decisions, the intention is actually not given much weight, if at all. It's always the impact that it has on the person who's the subject of the racism or discriminatory behavior. But here the arbitrator said that they did not find that there was an intention or an ill intention to promote racism. And they found that it didn't conclusively lead to a poisoned work environment. Importantly, as you'll recall, the employer did rely heavily on the noose incident. And what the adjudicator said there was that they asked him why they think someone would put a noose in the workplace. And the employee's response was he didn't know, but he thought it was probably a joke. The arbitrator said that the employee was essentially entitled to his opinion, and that an employer would want an employee to be forthcoming and truthful when answering in an investigation. And so the arbitrator said that essentially the employee could not be penalized for his own view that the person who did it, which wasn't him, the person who put the noose there probably did it as a joke. But one of the things that we highlight this decision for is because the adjudicator here, and if you could just flip to the next slide, please. The adjudicator here did take note of the fact that society is changing and that EDI is becoming more and more of a concern and more of a focus, not only by society, but by adjudicators. So here, the adjudicator said, societal views are changing and education seems an appropriate method of helping workers and others to understand the historical meaning and the reason for the negative symbolism of the Confederate flag. He also noted that the employer planned to hold educational sessions on the subject, such as unconscious bias and racism later last year. So the adjudicator said, I certainly commend the employer for those efforts, and I have no doubt the griever would have benefited from such education. So not to say here that a policy would have necessarily saved the day, but it certainly would have gone a long way to helping at least this employer in this instance be able to have, taught or trained their employees on what is considered discrimination, what is considered racism, going through some of the concepts we went through earlier in this presentation to ensure that its environment was not one that was discriminatory or where there was unwelcome behavior. Doesn't mean that things won't come up, but it certainly would help. And finally, if you could just go to the next slide there, perfect. He also recognized that we are in an era of heightened awareness of systemic and individual discrimination, and also noted that we live in an era where much more is being expected of companies and organizations to eliminate racism and discrimination in our diverse multicultural workplaces. That also means much more is expected of employees. So I'm going to stop there on that decision, just being cognizant of the time. But this decision is an important one for highlighting that, notwithstanding that the termination was not upheld, the adjudicator still took note of the fact that employers have to be very finely attuned to these issues of EDI, and that had this been a situation where the other factors such as progressive discipline and the like were implemented, this would have likely resulted in an automatic dismissal. So again, just being cognizant of the time, I'm actually going to flip through, not to the next decision we were going to talk about. So if we can just flip through a few slides ahead. The last decision I'll quickly talk about is the Ahmed decision. Perfect. So this one's an interesting one because, as you'll see, the employer actually did a lot of the right things, but yet still there was a remedy awarded to the applicant. But it does highlight the importance of doing the right thing, how that can help mitigate against the liability that you may face as an employer if one of your employees engage in discrimination. So this one deals with institutional bias, and the applicant here was a mechanical engineer working at the company, and he brought an application alleging discrimination and harassment based on a number of grounds, including race, color, citizenship, and ethnic origin. So the applicant was a dual citizen of Canada and Bangladesh and identified as a visible minority. So part of his allegation was that himself and other racialized employees were subjected to different management structures, reporting relationships, and unfair performance management. And so what he'd said was that the company failed in many respects to treat employees similarly, or to ensure that employees were not treated differently on improper bases. So here, I'm just going to, again, because of time here, I'm just going to flip ahead to the next slide. So here, prior to the human rights application, he did complain to his employer, and they actually did have a third-party investigator come in to do an investigation. And they actually did essentially find that there was an institutional racism and bias within the workplace. So I'm not going to go through everything here, but essentially the company took a number of steps to rectify the issues. Some of that included restructuring the department, granting the applicant a salary increase that was in line with other people of his vintage, and offered him a lump sum payment. Next slide, please. Notably, because the investigator found that there was institutional bias and racism within the workplace, the employer actually admitted to a lot of the misconduct. And ultimately, the tribunal did find that the applicant, based on the company's admissions and based on the previous report and the tribunal's review of the circumstances and facts themselves, they did find that the applicant was subjected to a racially segregating reporting structure, and excluded from client-facing events for years, that certain white employees would not deal with the applicant or other racialized employees and would instead ask other employees to communicate with them, and that they were not given, priority work. Sorry, the priority work was given to white employees over the racialized employees. So there were a number of findings of racial discrimination with the workplace. Next slide, please. And the remedy here was $30,000. So what I want to just quickly highlight before passing it back over to David is that Here, what many of you might be thinking is, well, the employer did the right thing. They recognized their wrongdoing. They had this investigated and recognized their wrongdoing, tried to remedy it. And what the tribunal said to that is essentially that, yes, the employer did the right thing here. However, there was still a violation of the code. So they did find that there were a number of mitigating factors. So the fact that the employer reacted promptly and reasonably to the applicant's internal complaint was seen as a mitigating factor. And the tribunal actually said that they would have awarded a higher damages award had the employer not taken these proactive steps. So with that, because we're kind of running low on time here, I am going to quickly give the floor back to David. Unfortunately, we're going to have to skip over a couple of slides here, but we also want to make sure we do have some time to address some Q&A. So I'll hand it back over to you, David.
Thanks, Nicole. Slides, please. One more. And another. Thank you. And before I talk about the increased liability risk, just comment on the Coca-Cola decision very quickly that Nicole raised. I think it's a good example and good warning that there's risks on both sides. So there's risks both from not doing enough from an EDI perspective, and then there's risks if you overstep and you at least as an arbitrator or adjudicator may look at it overstep on the other side of things. I think Nicole's point is a good one. If this had been a human rights complaint, it would be a different analysis. This was a labor arbitration. A labor arbitrator is looking at the issue of whether or not that employee, there was just cause for their termination. So it's a different kind of view, but it does serve as a good warning to organizations that there's risks on both sides. And now, if we haven't scared you enough to this point, now let me talk to you a little bit about these injury to dignity damages and what's been happening there. The quick update. So in BC here, I'm not going to get into the details of any of these cases, but the highest award of injury to dignity, recent decision in France is $176,000. And that is just injury to dignity awards. There was on top of that, all sorts of wage loss and other things. So that was just for the fact that there was discrimination and for the hurt feelings that arose from that. In 2020 in BC, injury to dignity awards, you'll see that the sort of average there, it's quite high. It used to be, my practice, when we're talking about injury to dignity, we were talking, between 2,500, 5,000 was a normal average kind of award. Now you'll see there 17,500. Well, I won't go through them all, but almost all of them were at least in that 15 plus kind of range, and all the way up to that 176 as you saw. So there's a lot more money in it now and bigger risk financially for organizations in BC. Next slide, please. Nova Scotia, there was an award, 80,000 injury to dignity, and you'll see the reasons there. And there was also an additional award of 25,000 to the wife of the complainant, who actually wasn't even a complainant, for injury to dignity because the discrimination was really directed at her. So again, a pretty big number there. Next slide, please. In Manitoba, there was a $75,000 injury to dignity award. But Manitoba has introduced a bill that to limit injury to dignity to just 25,000. So trying to cap where that is. So a little bit of a different trend than some of the other areas of the country. Next slide, please. In Ontario, in 2019, there was a $200,000 award there. And again, not getting into the details, but very significant numbers that we're talking. Next slide, please. Alberta, we're not talking about the number themselves, but it was referencing a lot of the decisions we've just gone through, and their Human Rights Commission explained, citing those decisions of support for the principle that damage awards for human rights violations are increasing. That without a legislative cap, there's no limit to the damages so long as they remain compensatory in nature. So a recognition in Alberta that there is this increase and they can basically go up as far as they feel necessary, unless there's a cap like was being introduced in Manitoba. Next slide, please. So with that, I'm going to hand it back over to both Nicole and Sandeep to conclude with some strategies. Hopefully we still have time for some questions at the end.
Perfect. Thanks, David. So I think what message we really want to leave everyone with is a couple of things. So first and foremost, EDI is important to all of your organizations, or should be important first and foremost because it's the right thing to do. You should want an environment that embraces EDI. However, as we've talked about in this discussion and presentation here today, there are a number of other reasons why you want to focus on EDI. There's a business reason. You want to make sure that your organizations reflect the communities that you live in, but you also want to be very mindful of the risks that we've talked about. And they can, as David just explained, can be quite high, upwards of $150,000 in damages if you don't properly account for EDI, ensure that you have policies on it, ensure that your employees, your managers understand what that means and how to ensure that they avoid situations where discrimination is present in the workplace. Next slide, please. What I also want to highlight is that it's not enough to just, have an environment where you're trying to ensure that it's inclusive for everyone. What people are expecting more and more is that you actually are anti-racist, that you're very actively against racism and systemic discrimination in the workplace. A couple of the slides that we skipped over were the cancel culture slide. And so we're really in an environment, and some of the decisions that we read from, there's widespread recognition that we are an environment now where people have zero tolerance for these types of things. And so beyond just the legal risk that exists, there's a very serious reputational risk that can exist for organizations that don't take EDI seriously or don't properly account for it. I'll hand it over to Sandeep quickly, and then hopefully we can get to a question or two from the audience.
Thanks, Nicole. I think throughout the presentation, we've covered a lot of sort of the defensive and proactive strategies that we can take. So I feel like I'd just be reiterating different pieces. I do think there's some value in taking some questions now. I'm just going to go to the questions, and there's probably a really one that's pretty easy that we can quickly go through. The first one is, for the pre-approval for special programs, do we have any sense of how long this process takes in BC?
Thanks, Sandeep. I'll just very quickly comment on that. The good news is it's been moved to the BC Human Rights Commission from the tribunal. The tribunal is very, very delayed and backlogged. I can't say for certain how long it would take with the commission, but they've got far more resources and capacity to handle it. So I don't think it would take overly long, though I haven't recently been through the process with them, so I can't say for certain.
Great, thanks. Another question is, can you provide an example of a harassment policy provision that you'd consider overly broad?
Sure, yeah, thanks, Sandeep. Again, and in the interest of time, I mean, I've seen these quite frequently in all sorts of policies when going over them with organizations, because again, a lot of the time the intention is really good, but it's really the choice of language. So for example, an organization that includes in its policy that it will ensure a workplace free from harassment and will prevent any employee being subject to harassment. Well, that sounds good. It's over-promising. If you're saying you will ensure, I would suggest don't do that. Say that you will strive to, or you'll do your best to, or something that qualifies it, not that you actually will. And will prevent any employee. You will take steps to address those sorts of things. So it's choice of language, not overstating.
Great, thank you, David. There's a question here related to the "you are so articulate" example that we used for microaggressions. And the question is, does "you are so articulate" have to be a microaggression? What if it's truly meant as a comment of admiration from someone who may not be so articulate? Do you have to assume that it comes from a place of surprise? I'm happy to quickly, hopefully, take this question. I think that's a great question, and I get it quite a bit. I think actually we can build on the Coca-Cola decision there, is that there is an expectation now that people understand that some of these terms, or the history or experience of those who are historically underrepresented or racialized, and how some of these comments or the assumptions, there's a history to that may cause a trigger, and so it's up to us to be a bit sensitive to those terms. And so, while it may be a term that comes out of admiration, and that's where it's the genuine, that's where the intent is. It's really looking at what the impact is to the person who's receiving the comment. Nicole, did you have anything to build on that?
Yeah, thanks, Sandeep. I would say context is everything. In certain contexts, it might be perfectly appropriate to comment on someone speaking very articulate, being very articulate in how they speak. And, perhaps you're their mentor and you're commenting on that because you've dealt with this question of, communication style before. Context is everything. I think kind of in the example that we discussed, it's where it's coming from a place of surprise and where there's a tone of surprise, where it can be problematic. But there's the problem sometimes is that there can be gray area. But I think what's most important is to be mindful, of how certain terms can be can have an impact on someone that maybe you didn't intend. But context is everything. So to answer the question, yes, absolutely. In certain contexts, that there's no issue with making a comment like that. It depends on the context and how it's said, why it's said, and how the person received it.
Thanks, Nicole. Just mindful of time, and I think we are at time, so I'm going to pass it back to David. Thanks for that nudge there, David.
Thanks, Andy. Appreciate that. And just to be respectful of everyone's time, we know you all have a lot to do. So just wanted to first say thank you for taking the time to join us. We do appreciate you spending the time with us. Just a quick reminder, please do, if you have the time, complete the survey that you can find at the bottom there. And last reminder, we'll be beginning our 2021 Year in Review Premier Webinar Series in November. So if you want to sign up for those, please, we'd be happy to have you join us. Thanks again very much for your time and attention.